Okay, so I want to talk about the difference between an in-law apartment and how that is distinct from a property that is a legal two or multifamily home. So, an in-law apartment, or some call it an accessory dwelling, is designed for someone like extended family to live close to the primary residence, either near or around it. It could be a separate structure outside, like maybe a little tiny house, or like a finished area that does have maybe its own kitchen. It does, to the naked eye, look like it could be a two family, but it is not, because it can't be monetized. That doesn't mean that Aunt Gertrude can't pay you a little rent, but it does mean that you can't advertise it as an apartment after Aunt Gertrude goes to uh, the next place. So a two family home is going to have separate utilities. It's going to have a separate address, as a matter of fact, between the living units. And it is obviously monetized, can be advertised for rent. Um, an in law apartment or an accessory dwelling is always part of a single family home. It is not meant to be monetized or advertised as a separate place. Oftentimes, the utilities are not separate. Almost always, they're not separate. And it is still a single family dwelling. If you are listing or selling a single family home with an in law apartment, you've got to make it clear that this is not a two family home and that the next owner cannot advertise that unit for rent or monetize it in a commercial fashion. It's pretty clear, but it needs to be explained sometimes because for a lot of people, the lines blur. So, in law apartment, accessory dwelling to a single family home, can't be commercialized or monetized publicly. Multifamily home, you can do all that. Hope that makes a difference. And if you have any further questions, reach out and I can do a deeper dive for you anytime with absolutely no obligation. I am here to help.